This is the Michigan Court of Claims case 20000108, Michigan Association of Retired Persons versus Jocelyn Benson, Secretary of State. This is a hearing on the motion for preliminary injunction. If you could please invite all participants to enter and unmute. We should have, on behalf of the state of Michigan, attorneys Heather S. Meingas and Eric A. Grill. On behalf of the plaintiff, appearances have been placed on the record by Sarah Prescott and pro hoc vice admitted individuals Uzoma Nkwanta, Mark Elias, Jackie L. Anderson, Courtney A. Elgart, Jyoti Jasasaria, and Rena Alman Griffin. And if the parties could be admitted, unmute yourself and make your presence physically seen on the screen, I would appreciate it. First of all, I would indicate that our court reporter is recording as well as we are recording audioly or visually rather, this hearing. If at any point in time she cannot hear what is being said or cannot understand what is being said, she will unmute herself and immediately interrupt whomever is speaking, whether it is myself or one of you, so that we have the opportunity to make sure that we have a clear record. If at any point in time in your transmission, you find that the gods of telecommunication have decided to freeze you or do something else untoward, while I understand you may not be able to be heard on that, raise your hand so we know, and we'll give you a moment until you either come back in on another piece of equipment or the equipment on which you are working unfreezes itself. Can we all nod an understanding of that? Okay. With that, on behalf of the plaintiff, if you can state your multiple appearances and tell me who is actually going to argue.
Good morning, Your Honor. Uzoma Nkwanta on behalf of the plaintiffs, and I will be arguing. And I'll let my co-counsel introduce themselves.
Thank you.
Good morning, Your Honor. Sarah Prescott, I'm local counsel.
Good morning, Your Honor. Jackie Anderson on behalf of the plaintiffs.
Good morning, Your Honor. Courtney Elgart, also on behalf of plaintiffs.
Good morning. This is Jyoti Jasasaria on behalf of plaintiffs.
Good morning, Your Honor. Rena Alman Griffin on behalf of plaintiffs as well.
And on behalf of the defendant?
Good morning, defendants. Good morning, Your Honor. Heather Meingas from the Attorney General's Office on behalf of Secretary Benson and AG Nessel.
As you are aware, previously the Michigan House of Representatives and the Senate filed a motion to intervene. That motion was denied by the court, but they were granted amici status. A motion to intervene was filed apparently at 5:30 on July 2nd, the day before the court closed, by the National Republican National Committee and the Michigan Republican Party. I did not receive that actual motion until Friday. I have not issued a formal order, nor have you had the opportunity to respond to that request to intervene. I think I know the answer, but I would ask first on behalf of the plaintiffs, are you in receipt of the motion?
Yes, Your Honor. Plaintiffs have received the motion and we oppose.
On behalf of the defendants, are you in receipt of the motion?
Yes, Your Honor, we also received the motion, and if given an opportunity to respond, we would likely oppose it as well.
The court reviewed the papers and did not believe that intervention as of right existed, and nor do I believe that permissive intervention is called for in this case. The court will allow them to have their papers received as amicus briefs and will review them. It is my intent to rule on this matter no later than next Tuesday, if at all possible, so that you can all go to the Court of Appeals where we all know you're heading. So we will give them the opportunity to have their point of view shared with the court and therefore properly before the appellate court in a timely manner. With that, the next question would be, this is a trifling matter, but I want to make sure that it's taken care of. While the court ordered that the responsive papers be filed by noon, for whatever reason, we didn't get them till 5 o'clock. I would presume that the plaintiffs waive any objection to that few-hour difference. Is that correct?
Yes, Your Honor.
Okay. And with that, could we proceed to hear your argument on the merits?
Thank you. May it please the court, Jocelyn on behalf of the plaintiffs. Your Honor, today we move for preliminary injunction with respect to two specific provisions. Two provisions from Michigan law that restrict the right to vote and also violate the First Amendment and free speech and associational rights of our plaintiffs. First provision is what we refer to as the ballot receipt deadline. That provision requires voters to have their ballots submitted and delivered to election officials by the close of the polling on election day, which would be 8 p.m. on election day. Now that ballot receipt deadline, which is set forth at MCL 168.764A and MCL 168.765, 3-5, that ballot receipt deadline, we argue, violates several provisions of the Michigan Constitution, but most importantly, it violates the most recent addition to the Constitution, which is a self-executing right to vote absentee by mail or in person within 40 days of an election. Now, the Secretary seems to concede that this constitutional provision has been violated, and for good reason. There are two different ways in which the ballot receipt deadline violates the self-executing right to vote absentee. First, it prevents voters from casting an absentee ballot by mail up until the last day before the election or on election day. Because if a ballot is received after election day, regardless of when it was mailed, that ballot is rejected as unlawful. And it prevents voters from having the choice to vote whether in person or by mail, absentee. In other words, it prevents voters and denies them the choice to cast their ballot in person or to submit their absentee ballot in person, or to send that same absentee ballot by mail within 40 days of an election day. And here's how it does that. If a voter submits a ballot by mail, perhaps a week before election day, which they're entitled to do now under that self-executing right, or under Article 2, Section 4, the voter may not have their ballot counted. And we all know that the right to vote also includes the right to have one's ballot counted. And because Michigan law currently denies voters that right, it cannot stand, and it's in violation of the self-executing right that was enshrined in the Constitution by an overwhelming majority of Michigan voters. The Secretary has raised a potential conflict or reasons why this court should not rule on the motion, notwithstanding her agreement with our position that this does violate Article 2, Section 4. The Secretary claims that the current mandamus action is also addressing the same provision, and that the court's ruling, the Court of Appeals ruling on that mandamus action, would be binding over this court and may require this court to stay. In response to that, Your Honor, I would point to the Secretary's argument that our preliminary injunction is improper, or at least untimely, because of the Purcell doctrine. And I would also point to the court the way the secretary has tried to occupy both sides of this argument. The secretary is arguing before this court that it is too late to grant relief with respect to the absentee ballot deadline, to the ballot receipt deadline, and that the court should not upend the electoral process at such a late hour before the election, yet at the same time arguing that the court should delay its ruling and should wait to see what the Court of Appeals does on a mandamus action. The secretary cannot have it both ways and cannot occupy both sides of this argument. To be honest, both are wrong. First, the mandamus action, while it involves a similar issue with respect to the legality of the ballot receipt deadline and its compliance with Article 2, Section 4, that mandamus action also involves issues that go beyond the merits. And while we certainly agree with the petitioners in the mandamus action, and we certainly believe that their points in that case are quite compelling, the court cannot sit by and wait for a ruling on an issue while time ticks and the secretary continues to argue that it's too late to grant relief. The court can issue its own independent ruling, and if the time comes where there's a ruling from the appellate court that requires an amendment, the court would have the freedom to amend its order.
Okay, counsel,
Yes.
what I need for you, okay, he's saying no video. Can you see me?
Yes, I can. I can see you, Your Honor. Can you see me?
Okay. My iPad just blanked out. It blanked out at the very beginning of your argument, and so I have heard none of it. So having done it brilliantly once, you get the opportunity to resume with the ballot receipt deadline. Yes, I carry a second iPad. Don't even, that this is why.
From the very beginning, Your Honor?
From the top.
Okay. Your Honor, plaintiffs seek an injunction with respect to two specific provisions of the Michigan election laws. The first is what we have termed the ballot receipt deadline. And the ballot receipt deadline prevents voters from casting an absentee ballot that arrives by mail after the deadline of 8 p.m. on election day, which is when polls close. In other words, the law requires voters who vote by mail to have their ballots delivered to election officials before 8 p.m. on election day. And that violates Article 2, Section 4 of the Michigan Constitution, which is a self-executing right enshrined in the Michigan Constitution by an overwhelming majority of Michigan voters in the 2018 general election.
And counsel, I understand that earlier in the pandemic, we were in a situation where it was a known fact that mail service was horribly interrupted, to the point where the United States Postal Service indicated that for certain zip codes that service was being delivered every other day. At this point, you're asking me to declare that we should enjoin, pardon me, this particular provision with the society being in a different phase. Why is it that this under Anderson verdict is unduly burdensome?
Your Honor, to answer that question first, we argue that this law violates the self-executing right under Article 2, Section 4 of the Michigan Constitution, which grants voters the right to vote by absentee ballot, either by mail or by submitting that ballot in person up to 40 days before election day. That provision and the alleged violation of that provision is not subject to Anderson verdict. Because it's a self-executing right, the legislature cannot enact provisions that restrict that right or that impose additional obligations and that frustrate the voters' intent in enacting.
So from your perspective, if I have a ballot that I decide to send at 7 o'clock on election day from Bangladesh, the vote cannot be counted until that Bangladesh sent document is received. We have to hold it open till forever.
Not necessarily, Your Honor. And I think there are two questions that I hear there from your question. First is if a ballot is sent from Bangladesh 7 p.m. on election day, does it have to be counted or accepted even though it will arrive well after election day? And B, doesn't that infringe upon the state's interest in the finality of elections? So I'll start with the first question. The first question, yes, the ballot has to be counted because under Article 2, Section 4, there is no limitation to that right to cast an absentee ballot 40 days before an election. And if you impose a deadline before election day, then you are infringing upon that right without authorization to do so under the Constitution. And the reason why is that 40-day mark. That 40-day mark is the window in which voters now have the constitutional right to cast a ballot. And also the provision gives voters the choice to cast that ballot by mail or in person. And if the state is to impose restrictions on the mail delivery of that ballot, then the state is not giving voters an equal choice to cast a ballot in person or by mail. And that is a violation of Article 2, Section 4. Now, the second question about the finality of the elections and whether the state is required to keep the elections open. The state would not necessarily be required to keep the elections open. And in fact, this is nothing new for the state. What the state would do in that instance is similar to what it does for military and overseas voters. Military and overseas voters, and the voter from Bangladesh would actually fall into this category, are able to receive extensions on that deadline depending on how late they receive their absentee ballot. So if the clerk issued an absentee ballot at some point later than the 45-day deadline, the clerk is required to send their absentee ballots 45 days before election day. If the clerk sends it at some point later than that deadline, overseas voters get a corresponding extension. That extension is unlimited under Michigan law. And that's MCL 168.759A, subsection 16.
And I understand that, but I guess what I'm saying is the voter got their ballot at their home in Grosse Pointe. For whatever reason, they had to go to Bangladesh. They were not entitled to the extension as an overseas voter under the absentee ballot rules. They're just like they're my next door neighbor, and for some reason they went to Bangladesh and said, oh darn, I've got my ballot, let me put it in the mail. So what is the outer limit then for counting that? Because it didn't get the automatic extension.
So I bring up the extension to define the outer limit because the extension and the outer limit are actually interrelated. For those overseas and military voters, the extension can pass the 14-day certification deadline, but the state is permitted to certify its election results notwithstanding the extension, as long as the absentee ballots that are missing or outstanding do not change the results. So in other words, notwithstanding the fact that these voters may receive an extension and that the ballot may arrive after the 14-day deadline to certify absentee ballots, the state is still authorized in other circumstances, for example, with respect to those overseas voters, to certify the election even with absentee ballots outstanding. And that is precisely what the state could do here. There's no reason to suggest that this remedy, which has worked without a hitch for overseas voters, could not continue to work for voters in Michigan. A voter—
And why doesn't, so why, the Secretary of State is supposed to determine that she should apply the outer limits, as we described it, of a legislative enactment when the legislature hasn't acted?
The legislature has acted because that 14-day certification deadline is actually set by statute. And
no, they acted on behalf of, they acted in a context where there were military ballots, etc. So now we have a new classification of absent voter who is not overseas or military. And you would have the secretary apply that statutory timeline when the legislature has not acted as relates to that class of voter.
in response to that, Your Honor, I would clarify that the outer limit, which is the 14-day certification deadline, is not limited to military and overseas voters. That is a state certification deadline for canvassing ballots. In other words,
but you've said that they could. You've told me to draw an analogy, right? And that they can count the ballots, certify 14 days, but they're to count all of the ballots, the military and the overseas ballots, and now this new classification of no reason absent voter until forever, until those certify the election unless it changes the result. How do we do that? How do we do that practically?
Practically, I think with respect to military and overseas voters, they have the extension that allows the state to continue counting their ballots after the certification deadline.
Right. So you want me to apply that extension?
We're not arguing that all voters should have their ballots counted after the certification deadline, the 14-day certification deadline. What we're arguing
just those postmarked.
Well, we're not even arguing that those postmarked by election day should be counted after the 14-day certification deadline. What we're arguing is the 14-day certification deadline imposes the limit. In other words, there's no need for any additional legislation. There's no need for any additional rules to impose an outer limit because the state law already imposes that outer limit, which is that 14-day certification deadline. And state law even contemplates a scenario where there are absentee ballots that have not been counted by that 14-day deadline because they're still coming in. And that was the reason why I brought up the example about overseas ballots. State law contemplates that scenario where there are ballots that are properly submitted but have not been counted by the 14-day certification deadline. And state law in that scenario nonetheless allows election officials to certify the election anyway. And that is essentially the same rule that would happen here. That is the outer limit. The state can certify the election when it's time to certify the election. And the reason why that provides an appropriate remedy here as well is that unless there is some monumental collapse in the mail system, granted there have been delays, unless there is some absolute monumental collapse, most ballots, if not the vast majority or all that are postmarked by election day will arrive before that 14-day mark. So the outer limit is there and is set forth in state law. There's no need to legislate either through the legislature, and there's no need for any additional orders setting forth the deadline for counting these ballots because the law already sets forth the timeline for that. Now, granted that I'm not sure if I mentioned this before I had to start over, but I'll rephrase it again. The state argues that this issue regarding the ballot receipt deadline and its compliance with Article 2, Section 4 is currently before the Court of Appeals in a mandamus action, and that this court should stay its ruling while the Court of Appeals decides that issue because its ruling could be binding on this court. Hence the word could, because there are a number of issues with respect to a mandamus petition that go beyond just the merits of the issue at hand. Nonetheless.
Okay, counsel, I can help you on that one. I'm not going to stay. I'm going to issue, if they rule in before I do, so be it, and we'll be bound to the extent that it's applicable. If they don't, it'll still be okay. I think that everyone here is entitled to a full and expeditious hearing on all of these issues, and the opportunity probably not to do much before the primary election, but because this would apply to the general election, there would be sufficient time to get this decided by the highest court of the state should the highest court choose to take it.
Thank you, Your Honor. Given the Secretary's concession that this law likely violates Article 2, Section 4, I think that there is no reason not to enjoin this law. And in addition to that, I would point to the only potential opposition that the Secretary has asserted to a preliminary injunction, which is the public interest factors, the irreparable harm, the timing of this. The Secretary raises a Purcell argument and suggests that election laws cannot be altered this close to an election, or that last-minute changes violate individual rights or cause confusion. That it should not be an impediment to issuing any ruling in this case. First, the Secretary, as I mentioned before, has tried to occupy both sides of this argument by not only suggesting that it may be too late to issue relief, but also asking the court to stay its order and wait and issue relief even later and even closer to election day. Both arguments are inconsistent and cannot stand. Second, Purcell is not a magical pill and is not an outright ban that prevents all injunctions related to elections or election laws that are anywhere near an election. The court must consider the specific injunction requested and its effect on election administration. And the effect in this case on election administration actually falls on the voter, not the election officials, at least for the most part. The ballot receipt deadline and enjoining that ballot receipt deadline, and instead allowing voters to send ballots by mail and have those ballots counted if they are postmarked by election day, that affects when the voters' ballots are counted. But it doesn't require election officials to adopt new procedures. It doesn't require some upheaval of the electoral scheme. And in fact, one of the cases that the Secretary cites, Feldman v. Secretary of State in the Ninth Circuit, recognized this as well. And that case specifically held that enjoining a ballot receipt deadline in a preliminary injunction did not impose any undue burden on election officials and did not raise any Purcell issues because of the narrow form of relief and the fact that it only affected when voters mailed their ballots. The court has plenty of time to issue that order, and if the court moves expeditiously, the voters will have plenty of time to adapt to the order, which simply gives them more time to send their ballots. And finally, with respect to the ballot receipt deadline, even assuming that there was some reason to delay a ruling, or even assuming that the Court of Appeals ruled some point between now and Tuesday on the ballot receipt deadline, plaintiffs have presented independent grounds to grant the relief we requested, and that is through the Due Process Clause. The Due Process Clause prevents laws that unlawfully undermine the fundamental fairness of an election. And there are a few things that undermine the fundamental fairness of the election, quite like following the voting procedures prescribed by the state and yet having your ballot denied. The state allows voters to submit ballots by mail, in fact, guarantees voters the right to submit ballots by mail, and yet denies and rejects those ballots submitted by mail for reasons that have nothing to do with the voter. In other words, a voter in Detroit and a voter in another part of the state could submit their ballots on the exact same day, and one person's ballot could be counted and another person's ballot may not be counted. And both voters are following procedures that were implemented by the state. And both voters are following procedures that have been advanced by the state as the proper means of voting. And we cited numerous cases in our brief, or we cited at least one Sixth Circuit case to demonstrate that when you are following election procedures that are prescribed by the state, and the state denies you the right to vote, even after following those procedures, you are entitled to relief. And that is a due process violation that alters the fundamental fairness of the election. So even if the court were to find some reason not to rule on our first grounds for relief, which is that the receipt deadline violates Article 2, Section 4, the court and the Equal Protection Clause claim, which is also before the Court of Appeals, the court should grant our relief with respect to the due process claim, because there's no question that what befalls voters who submit their ballots by mail is a fundamentally unfair system where voters have no idea after they submit their ballots whether their ballots will be counted or not. Unless the court has any questions, I'd like to move on to our voter assistance ban claim and our request for a preliminary injunction with respect to the voter assistance ban. Now, the voter assistance ban prohibits almost all adults in Michigan and almost all Michigan voters from seeking assistance in returning their absentee ballots unless they seek that assistance from an immediate family member or a member of their household or their local clerk or an assistant to their local clerk. And the immediate family member includes individuals like parents, siblings, spouses, and even in-laws. The rationale for this restriction is unclear at best.
Well, I assume the rationale is that we want to avoid North Carolina.
That may be the rationale. Two responses to that. First, that's not the rationale that the secretary asserted, nor is it the rationale that was advanced in the legislative history that the secretary offered. And two, the events of North Carolina were actually not caused by ballot delivery from third parties. Actually, North Carolina prohibits third-party ballot delivery, and that specific order in North Carolina, issued by the North Carolina State Board of Elections, found that the perpetrators of this fraud were able to escape detection because they did not deliver the ballots in person. What they did instead was they actually walked the voters to the mailbox, or they delivered the ballots through mailboxes that were near the voters' residences. So what they were able to do was they were able to avoid detection, specifically because they didn't have to go into the clerk's office and submit the ballots on their own.
So we have a current situation in Michigan where persons who are residing in assisted living homes who may well be intellectually competent but physically incompetent. From your perception, who, if anyone, because nobody can come in the nursing home, could deliver their ballot? Who could help the disabled elder who is intellectually competent, who wants her absent ballot delivered?
In that case, the only individuals I can think of would be either the clerk or an assistant to the clerk, assuming
And the clerk
can't
come in the nursing home either.
And that underscores our point that no one can assist that voter. Not only does that violate that voter's constitutional rights, but that also expressly violates the Voting Rights Act, Section 208 of the Voting Rights Act, which gives voters the right to select an individual of their choice to assist them in voting. And that is not just limited to the ballot box, that also includes aspects that are necessary to facilitate the act of voting, like submitting an absentee ballot. Michigan law does not permit anyone other than a family member or an employee of the clerk to assist in dropping off a ballot. Now, to the extent that
does the individual have to be an employee of the clerk?
Not necessarily. The individual can be designated by the clerk and can apply to be an assistant. But the fact still remains, and there may be home health workers that may be able to assist or apply to be assistants to the clerk. But the fact still remains that the disabled individual's choice has been restricted in a way that violates the Voting Rights Act, and that cannot be read consistent with the Voting Rights Act. And also, that individual is limited to assistance by the county clerk or their delegates up until 5 p.m. on the Friday before Election Day. So
So how do we manage the arguments about, quote, integrity, close quote, of the election, where it's asserted by some that political operatives will harvest basically a series of ballots and in some way affect the integrity of the election by doing so?
Your Honor, to that I would say the Constitution, both the First Amendment and the right to vote, demands much more than vague assertions of voter fraud or vague assertions that some activity may undermine the integrity of the elections process. What the state's obligation, the secretary's obligation here, is to explain what specific interest is advanced here and how that interest is advanced by the voter assistance ban. And clearly,
Well, that was in fact the state's. Remember, I've not just heard from the state in this, right? I've had the privilege of hearing from other individuals who are asserting that this is an election integrity issue, other than the Secretary of State's argument.
Yeah. And it's not an election integrity issue because there are numerous other laws in Michigan to prevent whatever election integrity issues that the state or other individuals may be concerned about. It is illegal to offer something of value to a voter. It is illegal to coerce a voter while they're filling out an absentee ballot. It is illegal to forge an absentee ballot or tamper with an absentee ballot. So what more does the state need in order to ensure integrity, especially when the state has not tied the act of delivering a ballot, delivering a third party's ballot to any fraud? And we submitted a report from Dr. Ken Mayer. And in Dr. Ken Mayer's report, specifically at pages 11 to 12 of his report, he outlines the dearth of evidence of absentee ballot fraud in Michigan. And in fact, the limited instances where an individual has been prosecuted for absentee ballot fraud in Michigan, it's unclear whether it was fraud at all. Because what the state, what the secretary and the legislature and others have tried to do here is that they've tried to lump a number of different concerns together with fraud, and it's important for this court to disentangle them. And I'll start with the concern about political operatives reaching out to voters and assisting voters in dropping off their ballots. Now, the fact that this law may have been targeted to prevent political operatives from contacting voters or reaching out to voters and trying to get voters to submit their absentee ballot, that in itself underscores another reason why it's unconstitutional, because that's not fraud, that's democracy, that's speech. In other words, court after court has recognized that voter registration campaigns, for instance, where political operatives and third-party organizations assist voters and convince voters to submit their voter registration applications, those activities are protected by the First Amendment. The same goes for GOTV activities. There's nothing fraudulent about someone trying to convince a voter to submit an absentee ballot. And in fact, it is permitted in a number of states. And there's nothing fraudulent about taking a voter's absentee ballot and delivering it to a clerk. And the fact that the state and the legislature and others who have opposed such measures are unable to actually tie ballot delivery itself to fraud underscores the fact that these laws are actually targeted towards speech, not fraud. And if you look at the legislative history that the secretary cites in their brief, that legislative history is quite telling, because it discusses vaguely abuses of process, but doesn't explain what those abuses are. The only time that the secretary is specific in actually explaining what those abuses are is in discussing the activities of political operatives in assisting voters in applying for absentee ballots and in picking up those absentee ballots and in offering to help voters to return those absentee ballots. Again, none of that is fraudulent. All of that is speech, and all of that is protected under the First Amendment. Even if there were some merit to the secretary's concerns about the election integrity, their concerns would not stand up to the First Amendment rights that have been infringed here. In other words, the law that forecloses any third-party ballot delivery and actually restricts that ballot delivery to a very small category of individuals, goes too far in trying to reinforce whatever interest that the state, or trying to advance whatever interest that the state claims to advance here. Now, there are numerous cases, federal court cases, that have recognized that such activities implicate First Amendment interests in political speech. But I would direct the court to the Supreme Court's opinions in Meyer and Buckley. And in both cases, the court found that restrictions on initiative petition circulators violated the First Amendment. And while those cases involved initiative petition circulators, the doctrine that the court announced there and the rules that the court applied are equally applicable in this context, because the court did not slice and dice the specific aspects of initiative circulation and the specific conduct or the specific messages involved in initiative circulation. Instead, the court found that activities or restrictions that prevented initiative circulators from utilizing the most effective means of achieving their objectives, or that limited the amount of, or resulted in a diminution of the amount of speech, or that restricted the ability of initiative circulators to engage in that face-to-face speech, violated the First Amendment. And that is important here because the District of Tennessee in Hargett has also agreed that the court cannot slice and dice the different activities that comprise a voter registration drive. In other words, the court cannot separate the actual delivery of voter registration applications from the face-to-face contact, from the communication with voters that implicate political speech. And that same rule and that same analogy applies here. GOTV campaigns necessarily involve that face-to-face communication, necessarily involve political speech. And the secretary and the legislature's attempts to distinguish voter registration campaigns from GOTV campaigns just don't hold water. They suggest, for instance, that the decision whether to register is politically motivated and may involve political speech, but the decision whether to vote is apolitical. And that finds no support, and plaintiffs have not identified any law or authority that would support that distinction. And in fact, it's probably quite the opposite. The decision to vote and to vote for a specific candidate or specific issue is inherently politically motivated. And the discussion over those issues, the discussion over whether an individual votes and how an individual votes, necessarily implicates political speech. That outcome is demanded by the Tennessee federal court's decision in Hargett, but also by the Supreme Court's decisions in Meyer and Buckley. And there's no legitimate distinction between the GOTV campaigns of our plaintiffs, the Alliance for Retired Americans and the A. Philip Randolph Institute and others in Michigan. There's no distinction between their GOTV campaigns that aim to assist voters in submitting their absentee ballots, at the same time engage in political speech, and that the restrictions on that entire process violate the First Amendment and cannot stand.
Okay, I think you're done.
Lastly, I would like to.
You do know in the Court of Appeals you only get 30 minutes. You've now had 45. Yes, sir.
Understand, and I will be very brief. Lastly, I'd like to point out that the Secretary and the legislature do not offer any serious opposition to the notion that, or the argument that the voter assistance ban violates Section 208 of the Voting Rights Act. They point to several cases which are inapplicable here because the restrictions in those cases are nowhere near as restrictive as the case before us.
They point out that you don't get to pick anybody, that it is not without restriction. I read it.
Certainly, and plaintiffs are not suggesting that anybody, including children or prisoners, should be allowed to deliver ballots. Nor do we need to resort to those types of extreme analogies to determine this issue.
Well, actually, I'm going to tell you that I come from a household in which the immigrant grandparent was more challenged with English than the children. And the children, in point of fact, did help fill out the ballots. I know they did because my grandmother, while she could fully understand English and make a decision, reading it made her crazy. So there are two different kinds of assistance. And the concept of having assistance by a child who's more literate than an adult does not in any way, frankly, disturb me. I got the prisoner part, but.
Absolutely, Your Honor. And I would agree with that. And I think that is also, that is also reflected in what should be the leading case here, which is OCA Greater Houston v. Texas. And that should guide the court's decision here. That case was decided by the Fifth Circuit, and the Fifth Circuit limited the individuals who could provide language assistance to voters who were registered within the same county as the voter. So in other words, even if you had an adult with you, and even if you, or a child or anyone else who was able to provide assistance, they had to be registered in the county. The court found that restriction was not permissible and presented a clear conflict with Section 208 of the Voting Rights Act. The restriction here in Michigan is significantly more restrictive and significantly narrows the pool of individuals available to include immediate family members, assuming one has immediate family members, and in some cases, nobody, if we're talking about students who are away from home and who don't have household members, or if we're talking about disabled individuals who live in assisted care facilities or who don't have individuals to assist them. The restriction here goes beyond anything that we've seen, even in OCA Greater Houston v. Texas, and it cannot stand. And we ask that this court enjoin both the voter assistance ban and the ballot receipt deadline.
Okay. It's my guest.
Thank you, Your Honor. I think I just want to make our principal position today would be, I think the ship has sailed on any request for injunctive relief directed at the August primary itself. We're less than a month away, I think.
So why is the ship sailed relative to counting ballots? The ballots aren't in yet. We're not at August 8th. It's not August 8th at 8 o'clock.
That's true. I think the perspective from that one, I mean, despite what plaintiff's counsel has said, and the court has already indicated it's not inclined to stay this decision, these questions on the ballot receipt deadlines are pending in front of the Court of Appeals, and that decision is going to be persuasive or binding, on anything that this court does. And that court knows.
It's persuasive or binding. And so if they decide that there was no clear duty, that's a difference between saying there's no clear duty and there is no duty, or we don't know what it's going to be. And it would be, to me, absurd to say, I'm going to wait till we find out what we don't find out when we find it out. I appreciate that you, and I thought perhaps we would have a decision by now, but we're not there because we have the privilege of having 3 people who have to deliberate and confer and reach a decision. Here you're stuck with 1, it'll be faster, and you can everybody who disagrees with it can rapidly move on. But I don't think the ship has sailed argument doesn't work for me on counting ballots. I understand much of your argument about voter assistance because people have either chosen to get assistance from human beings or not. They've limited their pool already for this election, and yet there are people who haven't made the decision. There are people who are still saying, I have a 96-year-old aunt who is so delighted about the concept of voting that absent really a plague, she's gonna go to the polls no matter what you do. But if in fact we have a resurgence of COVID-19, which we are having, she may well make the decision at the very last minute within the 40 days to execute an AV vote. And so people like that still have the option to make a choice. So that doesn't feel to me like the ship has sailed either.
Well, with all due respect, Your Honor, I do think that there is, whether you want to call it the Purcell Doctrine or latches or all that, I mean, there's a significant amount of authority that says we shouldn't be changing, long-standing election statutes or rules and regulations close in time to election. I think we're within that. I mean, I also think, whatever happens here, there has to be time considering for an appeal. So the idea that somehow there's going to be something that comes out of this that could really be at play or in play for the August primary, I really don't think that's the case. And also,
you also have the right. You make a decision on behalf of the AG as to each case, as to whether you're going to appeal or not. I presume you will, but I don't know that you will. I don't know that either. My obligation to rule is not dependent on that guess either. So either I've got to decide that Purcell says that this is such a drastic change that it substantially affects the quality and integrity of the election, or I don't. Counting ballots doesn't feel to me like it's a Purcell violation. The voter assistance is closer.
Well,
so tell me why the ballot counting is Purcell.
Well, I just think from our perspective, this is a huge sea change in how we do elections. If we're going to start accepting ballots after election day and going to figure out how and when to
start
count
accepting ballots other than the overseas and military. So it's additional ballots. It's not completely
right.
new.
I mean, AV and
it
overseas
is an expansion.
Right, AV and overseas ballots is a totally separate issue. It's a very small number of ballots that would come in. We're talking about all AV ballots by any other person, voted in Michigan.
And we're guessing how many of those would come in after the deadline, right?
Right, we would be guessing as to how many come in after the deadline,
okay.
But certainly some do.
Yeah.
So.
And if it's a few, it's a small change, and if it's millions, it's a different change.
That's correct.
I participated in elections where, because the polls were supposed to close at 8:00, and the world was such that they didn't need to close at 8:00 because there were people around the block, and people were told on that night they were given an injunction saying, keep the polls open until that last human being is counted. That happened at the absolute last minute, and that has been not held to violate Purcell.
Well, I think those last minute court orders to hold polls open are certainly a different scenario because they're making a decision under the circumstances, present at the time of the election. And so anybody, the general rule is that anybody in line by 8:00 gets to vote, right? So the question is people not in line holding it open later for people who haven't arrived in line, by 8:00. So there's a little bit of a distinction there, but I think we can respectfully disagree with each other on whether it's wise to make changes to the process,
It's not a question of, whether it's wise or not. The question is it legally appropriate? I don't get to make wisdom choices.
Right. And I guess my point would be it's not legally appropriate.
Okay.
So, but I think, so setting that aside, I mean, that's our position. I mean, that's our main principal position, that if there's going to be an injunction, if there's going to be something, it should be directed at November and not directed at August. But, moving to, what we said, as you saw from our brief, and as Mr. Quanta pointed out, the ballot receipt deadline questions, for the most part, are pending at the Court of Appeals, and we attached our brief for that to show our position and incorporate that here. As plaintiff's counsel noted, we are in agreement. Our position here is dictated by the position that was taken in League of Women Voters. And so that we do agree here that the ballot receipt deadlines do violate Article 2, Section 4, under Proposal 3, as amended by Proposal 3, with respect to the language of that text and an infringement on the self-executing aspect of that section. So we are in sync with plaintiffs on that front. We do disagree, and this is the same position we took at League of Women Voters. And that somehow the magical deadline would be the 14th day, that you could receive ballots all the way to the 14th day, when actually the election is supposed to be certified in each county by that day. Position that we took.
So here's the question for you.
Yeah.
If you agree that that the statute as existent violates the article, and you agree that there's nothing else out there, is my choice to say you are enjoined from enforcing that deadline and there's no deadline?
You could say that and say that that's up for the legislature to decide what the deadline should be. I mean, that is the arguments that we made in League of Women Voters. But if you saw from our brief,
which of course would lead us to worse than Purcell, because they could act on the day of the election. So.
Moving on, our position is that a more logical or rational deadline for receiving ballots postmarked by election day would be the 6th day, which is the deadline for provisional ballots. I mean, accepting ballots all the way through the 14th day. I mean, the election's supposed to be certified at that time. Ballots only.
So talk to me about why the provisional deadline is more persuasive as interim relief until the legislature acts than the 14 days.
From our perspective, the sixth day is the better deadline right now until the legislature could act, because AV ballots come into to city and township clerks, right? They're delivered to your local clerk. Mm-hmm. The 14-day election certification is done by the counties.
Yeah.
So you have to it would be requiring city and township clerks to be making sure that they've got all ballots delivered to the county and that the counties had time to incorporate any late arriving ballots. And there wouldn't be any time to resolve sort of like internal questions about the validity of a ballot or figuring out whether there's actually a postmark.
Whether the ballot numbers, the number of ballots.
Is there something wrong, with this ballot? And so waiting until the 14th day doesn't build in any ability for the state or for the city or township clerk or for the county clerks to make any internal, any resolutions as to the validity of a ballot if it needed to. And so from our perspective.
If I understand you correctly, if I understand you correctly, you're suggesting that I shouldn't act, but if I act.
If you act.
I should enter an opinion in order that indicated that for this election and or until the legislature acts more appropriately, that this court would impose the deadline of 6 days, which is the provisional ballot deadline, to afford the city and township clerks the opportunity to allow an orderly certification of the election by the county.
Correct.
Did I understand you correctly?
Yes. And I would also note that the 6-day deadline is currently pending as proposed legislation right now in the legislature. So House Bill 5807 actually proposes that 6-day proposes a 6-day deadline. So taking a cue from what's already pending there, that they haven't acted on it, but
I was actually the lawyer for the Senate. I don't take a cue from a blueback. We need more than a blueback, okay?
Well, I'm just saying that it's consistent. Our position would be consistent, at least with the legislation introduced currently at the House.
Okay.
So that's not dependent on that, but I'm just pointing out that in fact there is legislation pending and it also proposes a 6-day deadline. But for our purposes, yes, we think the provisional ballot deadline, which is another deadline right in a statute that you can point to as an interim measure until the legislature can act. And 6 days from our perspective is also a realistic amount of time, even with some potential delays in post office delivery, to the extent those delays are still continuing. I mean, I know my mail's not been interrupted at all throughout any of this, but I understand that other places.
But in terms of balancing, in terms of balancing burdens to the parties, potentially that has a persuasive impact. Okay. Is there more you would wish to say other than the 2 briefs you gave me?
On the ballot receipt deadline?
On the ballot receipt deadline, and then we can get to the voter assistance.
If the court doesn't have any other questions on the ballot receipt deadline, I
don't. Thank you.
Okay, that's fine. So on the AV ballot collection issue, oops, Judge, there you are. Okay, I thought you disappeared, but you're there. I think our position on that is pretty straightforward in the briefing. I think one thing that maybe wasn't clear, and this would be relevant for the argument as far as the speech and associational rights. I mean, we disagree that delivering an AV ballot for somebody is speech. It's not speech. It's conduct, and it doesn't get the coverage of the First Amendment protection simply by being attached to a speech element that exists before. But I want to point out today, and which didn't dawn on me so much last Friday when I was hurrying through the brief, was, as far as the organizationals, plaintiffs here interest in speech and association, to the extent there are any, they're not prohibited from assisting voters. I mean, they can become credentialed assistants and participate in ballot collection, in that capacity. So to the extent there is associational interest, and those are at issue here, which we don't agree, there is an opportunity for these organizational plaintiffs through their members to become credentialed assistants who can participate in ballot collection with the clerk's offices. So,
okay, Ms. Meingas, given our current existence in the land of COVID still, what do we do about that assisted living and nursing home individual who cannot have, it's not just, their children can't visit them, no elected official representative, i.e. the clerk, that elected official, can visit them. The only people who are allowed to be with them are their healthcare providers and their caregivers. So have we effectively then said to them, you don't get to vote?
No, I don't think so at all. I tried to communicate with my Bureau of Elections people while we were talking. Clerks often and can effectuate pickup ballots and do, from assisted living facilities and nursing homes and all of that. So the clerks already
They can,
do that.
and it's their choice.
Yeah.
And the assisted living people, I mean, again, the other 92-year-old, yeah, she's 92, doesn't have a phone. It's not, and if it's a huge nursing facility, maybe that one people go to that one. But if it's a little facility over in the corner in Highland Park that's got 80 beds, and of that 80 beds, 40 are not intellectually competent enough to participate in the voting process, but 40 are. And we're going to wait. We're going to say that, well, if the clerk makes a decision that she or he wants to go to that facility, then they can go collect them. The clerk is not required to do it, and the individual has no ability to self-actualize. What do we do about that?
Well, you have to remember that if a person has no immediate family member, which includes a wide array of people who could assist them somehow, and they're not able to call a clerk and arrange for pickup for whatever reason, obviously they still have the option to return their AV ballot by mail. I mean, there is some responsibility on behalf of a voter, Your Honor, to think ahead.
So the voter, the 90-plus-year-old voter in an assisted living facility who has minimal contact with the outside world and they cannot assist them is supposed to figure out how to get a stamp. When everything else, I would not. If we were not in COVID, I could understand it a lot better because there's an ordinary interchange. But people they can't get in.
Your Honor, I wouldn't understand that people in assisted living facilities or nursing homes are somehow unable to purchase stamps in some capacity. I mean, I highly doubt that. But
okay, you do. In a nursing facility, your money is kept in a secured account. if people could get it in the account, which has been difficult to do for the last 92 days, you would have to then be able to request that someone go buy stamps. The nursing facility would then have to go buy a stamp. And I hear you. I have practical experience with this that tells me that that's not going to happen, but I understand.
Well, I think we can respectfully disagree on issues. Yeah. I mean, and it's possible that there is a small group of individuals who, for whatever reason, have no ability to exercise any of these options, multiple options to return their AV ballot. The fact that some people might end up not being able to participate in the franchise does not mean that a state statute is unconstitutional. People are unable to exercise the franchise for any number of different reasons, and it doesn't make a statute unconstitutional. We don't need to test.
A statute that deprives an individual of the right to vote is okay, but it's just a few. Okay.
If a statute as a whole is fair and equal, it applies. The fact that it's the same thing if I, having polls only open till 8. If I come at 8:10, I'm out of luck. But the poll closing statute is not unconstitutional because I, couldn't exercise the ability to come in earlier or make other arrangements. I mean, I think that's analogous here. I mean, there are a lot of different ways for a voter to return their AV ballot. And if there may be situations where none of those options work, but looking at the statute as a whole, I mean, we don't have an as-applied challenge here. We have a facial challenge. So, so that to me, yes, all statutes that involve elections potentially have the option of excluding people for one reason or another, and it doesn't make the statute unconstitutional. So that would be my point on that.
All right, I understand. Thank you very much.
Sorry, go ahead.
Yes, ma'am.
No, I'm sorry, if you were ready to, if you had a question.
No, I thought that you covered both of your issues. I didn't know that you had more to share.
No, if the court doesn't have any further questions, I will stand on my brief. I also would say that to the extent our arguments are consistent with the legislature's brief, which they are, except for the one ballot receipt deadline issue that, I found those arguments to be compelling as well, and we would rely on those as well.
Thank you. Counsel, is there something that you feel compelled you need to say in rebuttal?
No, Your Honor.
Okay. I thank you for your excellent briefs and your argument. The matter will be submitted by the court. I trust you all have shared your information with our court reporter. The audio transcript will be available on YouTube, I guess, this afternoon, and the official transcript can be obtained from the court reporter. I'm sure quite expeditiously. I know that she knows that I'm requesting a copy yesterday, and she has been quite gracious and effective in providing me with those copies. Thank you all. Have a safe afternoon and stay cool. The court is adjourned. The court is adjourned.